Hey everybody, welcome back to the channel today. We are back on the lawsuit, which is Boland v. Bonta. That is CRPA's challenge to the handgun roster, which is a byproduct of the Unsafe Handgun Act in California. To do that with us today, we've brought on CRPA President Chuck Michel. Chuck, thank you very much for being with us today.
Always my pleasure.
Absolutely. But before we get into it today, we are so close to having 10,000 subscribers on this channel. If you haven't been with us before, we are doing a promo. Go ahead and drop a comment down in the comment section. Hashtag CRPA for the win. If you are subscribed, you enter a chance to win a Springfield XD, which we will be giving away when we've hit that 10,000 subscriber. And as always, be sure, like, share, subscribe to this channel. It really helps the algorithms. We're hoping that we earn that from you by bringing you this information so that we can spread it as far as we can. So when it comes time to vote, people can do it with the knowledge necessary to make informed decisions. All right, so we have a little bit of an update on the Boland case. Chuck, if you can take us there, just give us a refresher of what the challenge is. I know that it was appealed to the Ninth Circuit and some new voices that we've got involved here.
Well, I'll try not to get too geeky on this, but you have to understand a couple of nuances. First of all, generally speaking, this was CRPA's challenge to the roster law, the so-called Unsafe Handgun Act, which really had nothing to do with whether a handgun was safe or not, and more to do with how the state could ban as many handguns from being able to be sold in the state of California as possible. They started off with drop safety and a firing test, basically making sure the firearm didn't go off accidentally. And then they expanded it to add more and more and more requirements so that less and less and less guns could be approved for sale and then listed on this roster so that dealers could stock them and sell them. The most problematic were a loaded chamber indicator, a magazine disconnect safety lock, so the gun won't fire if there's not a magazine in it, and then microstamping, and that one basically killed the market. None of the manufacturers put in microstamping, and so the list of guns that were on the roster to be approved for sale went down to really right around 200 if you don't count, change different coatings or colors or metals. It's the same model with a slight cosmetic difference. So the consumer's choice was drastically limited and essentially nothing compared to the make and model of handguns that are available for sale in other states. So California gun owners have been deprived of the access to the latest and safest handgun models for over a decade. You can't pick a gun that's suited for your individual needs because there's not enough different models on the roster to really cover it all. So CRPA challenged that, and we challenged the entire Unsafe Handgun Act, but then sought a preliminary injunction against the loaded chamber indicator, magazine disconnect, and microstamping requirements, and we won. We got a fantastic ruling out of a district court judge that said that this is a violation of the Second Amendment, and under the Bruin test, you're banning commonly owned firearms. There's no that are chosen by the overwhelming number of Americans for self-defense or other purposes for that matter. It's not just about self-defense. So the judge enjoined the states, ruled that the state could not require the loaded chamber, magazine disconnect, or microstamping feature, and the state has appealed, not surprisingly. So now we are up on appeal in the Ninth Circuit. Our first brief has been filed, and it's a great brief. And the state filed its first brief, and they got a bunch of amicus friends of the court briefs filed in support of them. And then our opposition brief was filed, and we got a number of amicus briefs filed in support of us. And now the state will file its reply in a week or so, and then there'll be oral argument sometime in July. So this case is really moving pretty fast here, and we're doing everything we can to hold on to this victory, because really this is a Second Amendment violation it should be clear, but it's the Ninth Circuit, so who knows?
Well, I wanted to hit a couple things on that. So I think there's something to be said on how the state appealed and where we as the public stand now. But for the time being, I wanted to touch on these amicus briefs with you. So, CRPA lawsuits are no stranger to amicus briefs. But something that I did take note of is, first of all, 24 states filed in support of the CRPA lawsuit. And then not only that, but you had 14 states file to support the state. So first of all, can you tell us, what this really means on a national level for all of these states to be supporting CRPA? And then more alarmingly, on a national level, if you've got 14 states that are supporting the state of California in this lawsuit, does that carry implications that microstamping technology might be coming to other states?
Absolutely. And not just microstamping technology, possibly smart guns, biometrics, whatever. They want to be able to tell you what kind of handgun you can buy. And basically that selection is going to be, if the blue states get their way, the states that support this law get their way, there's going to be very, very few handguns that you can buy. This is their way to get around or try and get around the Heller and Bruin decision and ban as many handguns from being available to purchase as they can. Remember, years ago, they wanted to ban all handguns. That was their agenda for decades. Their true agenda was to ban all handguns. And Heller put a stop to that, and then they shifted to semi-automatic rifles. So they want to ban, they want to ban as many guns from as many people from as many places as they possibly can. And that's what these blue states, these progressive states in filing amicus briefs on support of the state are trying to do. They want to keep the door open for them to pass a similar or worse law in their state.
Yeah, and it's not really a secret anymore. I think we even recently had a situation where the head of the Brady Group was doing an interview, and she ended up saying something like, "No, ban all the guns." And the interviewer tried to give her a way to back out of it, and then she doubled down. She was like, "No, we want to ban all of these guns." So it's definitely an agenda that's not really being hidden anymore, but this is going to be interesting going forward. I mean, this is something that kind of started in California with this lawsuit, now has national implications. So something to be watching for on the federal level moving forward. But what about where we as Californians stand now? I remember coming on here doing a video talking about how they left microstamping off of the appeal to the Ninth Circuit, to later find out that probably the reason they did that is because they have a bill that would re-implement microstamping technology into the California penal code here. As it stands right now with the roster, microstamping, is that not a thing because of the injunction?
No, they didn't actually drop the microstamping argument on appeal. What they did was, remember, the court issued an injunction. Then it stayed that injunction for 14 days so the state could appeal, and the state did appeal, and then the state asked the Ninth Circuit to extend that injunction. We opposed that, but the Ninth Circuit did extend it. But the interesting thing was, in that injunction, in that request for a stay of the injunction, they did not request that the Ninth Circuit stay the injunction on the microstamping feature. In other words, right now, you don't have to submit a gun with microstamping to get it on the roster, but you still have to have the loaded chamber indicator and the magazine disconnect. There's some rimfire firearms where you don't have to have that loaded chamber indicator, or excuse me, the magazine disconnect. And so Ruger has gotten 2 new rimfire handguns on the roster in the last couple of weeks. But it's basically none of these manufacturers make a handgun with a pistol with both loaded chamber and magazine disconnect feature. So we still have hardly any guns available to buy. But I think the big lead story here is that we have 24 red states that have said this law is unconstitutional. And you've got this classical divide now between liberal versus conservative, for lack of a better, generalization, states in this country who who have different perspectives on what the Second Amendment means and what kind of rights it gives you. And that's huge. This is going to have to be, and there's going to be courts in those states who will go one way or the other too. I don't think we're going to get any uniform body of law necessarily nationally. I'm very hopeful, and I'm pretty confident that we will win in the Ninth Circuit. By the way, in addition to the states, we've got both state and national law enforcement groups that filed friend of the court briefs in support of CRPA, and including like the biggest law enforcement groups in the state of California: Peace Officers Research Association, California State Sheriff's Association, California Police Chiefs Association, the California Association of Highway Patrolmen, California Reserve Peace Officers Association. I mean, those are the biggest state level, California specific law enforcement groups that are in this state. And then we had some national groups join different amicus briefs too. So the police are not for this. They are starting to really recognize that the Democrat agenda, part of it is banning civilian firearm possession, but it's also shifting the whole way we treat crime, and take away people's ability to defend themselves and shift all that responsibility onto the police, which they can't handle it. They can't respond to prevent a crime. They respond after it's happened and take a report.
Well, yeah, I'm glad to hear that they are taking a stand, and this is a place that they're taking a stand at. Is that all that this really is, though? What do these amicus briefs from these law enforcement groups actually contribute to the case when it's in the courtroom?
Well, some of it is a reiteration of what's said in our main brief, CRPA's opening brief, but some of it goes a little further. They talk about common use in more depth. You know, the courts are trying to get. They also talk about whether or not it's amazing what the state, the desperate arguments that the state is making in the hopes that some biased judge will allow them to get away with it. They're saying that these aren't arms, that these are not, the state has the right to ban classes of arms. Then they're trying to make some kind of historical analogy, the arms that are protected by the Second Amendment. Then they're trying to make some historical, remember the Bruin test is, first, is it covered by the language of the Second Amendment? Second should be, is it in common use? Because if it's in common use, the Supreme Court has already done the analysis of whether or not there's a historical analog, in other words, an old law, that was around when the Second Amendment was adopted, that would indicate that the founding fathers would tolerate the modern law. And in Heller and McDonald, they looked at the historical handgun bans, found nothing that was remotely similar, and so said, no, there was never a ban on commonly possessed firearms in history. So you can't ban commonly possessed firearms. But the state is trying to now say, well, wait a minute, there were these laws from Massachusetts for a while where Springfield Armory was that required barrels to be proof tested. In other words, they did a little bit of testing on the barrel to make sure the barrel wouldn't explode. And they're saying, well, that's the same thing. Well, no, it isn't. These are so-called crime-solving features with microstamping, or consumer limitation features in the case of the magazine disconnect or the loaded chamber indicator. Those are not things that are designed to test whether or not a firearm is safe and will perform as it's intended. Those are things that are designed to impose additional restrictions on the things that a gun can or can't do. So those are totally different. They're not historically applicable. But that's what the state is trying to argue. They're grasping at straws for these historical laws to try and claim that this gives them the authority to ban them today. And so it's very helpful for law enforcement to talk about that and say, you know, we don't need this crime fighting tool. It's not a real crime fighting tool. And then the other briefs cover similar things. National Shooting Sports Foundation submitted a brief that talks about how many people buy handguns, what kind of handguns are chosen, what kind of problems the microstamping and loaded chamber and magazine disconnect features create for manufacturers, how they can't, manufacturers, first of all, the consumers don't want these features. But second of all, the guns are designed to function in a certain way. And when you start putting all these additional features, requiring these additional features on a handgun, it screws up the way the gun functions for whatever individualized use it's intended. Every gun has to be, ergonomically designed. The caliber is chosen based on the person's preference. The barrel length, all those things go into designing a gun that's right for a specific type of person for a specific purpose. And when you start just slapping on these additional features, you don't have the leeway to create guns that are more individualized or suitable for more individual circumstances. So all these briefs kind of really get into the more detail on that. The main party brief has page limitations. We were limited to 25 pages. So some of these briefs have taken the opportunity to use their pages to really elaborate on some of the points that we were making in our main brief. And that's very helpful.
Well, I can't tell you, I was talking to Sam Paredes a couple months ago, and he was just talking about how the path to victory seems a lot easier now on well, I don't want to say easier, but a lot more clear on a lot of these cases. This is, some laws that have been in effect for decades. This isn't a law that was passed last year that we challenged this year and has been fought against and failed a couple times. I can't tell you how excited I am to finally be making progress, finally start seeing decisions that go in our favor, in the favor of our rights, which is awesome. We're gonna keep following this. You might see it on the national media. And if you do, go ahead and try to remember the way that things are framed, but we're certainly going to continue following it here as well. Chuck, I really appreciate the clarification. I really appreciate you taking the time to come on.
Yeah, it's going to be a fight. It's not over. Whatever you can do to support the CRPA's efforts and the Second Amendment Law Center, for that matter, which is coordinating amicus brief campaigns like were ran in Boland in multiple other states now, because these amicus briefs are really a very critical part, very important part of all Second Amendment litigation because of those page limitations and because of the unique perspectives that some of these amicus parties, the groups that are signing on to these briefs can make to really expand the court's exposure to how these laws will affect different groups and how the court's decisions will influence public policy in good or bad ways. So it's a very exciting time. It's a historic time for the Second Amendment. The cases like Boland and all the other cases, the semi-auto ban, the magazine, the standard capacity magazine, the ammunition background check, the taxes, the sensitive places, restrictions that they're trying to put on good cause. All those cases need to be litigated, and all those cases are going to make legal precedent that is going to be used to litigate future cases and take back some of the rights that have been really stolen from us by the rigged Sacramento legislature for a long time. So it's time for a Second Amendment reckoning, and it has begun.
Yeah, I feel like we're living in it. Chuck, I'm sure we'll see you again soon. Thank you again very much for coming on. And this is a really good time to be in this fight, and you can contribute to it just by clicking a button on your phone. It can be that simple. So I'll say it one more time. Please go ahead and like, share, and subscribe to this channel. It really helps get the information out there so that people can be armed with this information, whether they're talking to somebody in their family or going to vote for their next legislator. So please go ahead and do that. We are almost to the 10,000 subscriber. If you didn't see at the beginning of the video, drop that hashtag CRPA for the win for your in the comment section for your chance to win that Springfield XD. Thanks, guys, and we'll see you on the next one.